Hey everybody, Dan McKenzie here, coming to you from Ottawa. Really sorry I can't be there today to discuss all this with you guys in person, but we'll do the best we can in the circumstances. I hope you all enjoyed your mock trial and were able to see a good examination in chief and an even better cross-examination where Mr. Kofsky's credibility was successfully undermined. For my portion of the presentation, I kind of want to give an overview, and it will be a very broad overview as these are very big, all-encompassing topics, is sort of reinforce the art form that is at place in cross-examination and as well as examination in chief, and some of the different tricks of the trade that people employ and different ideas of what makes a successful examination in chief, what attributes a counsel should portray and how it should be done, as well as in cross-examination, very different processes for counsel, as I'm sure you're aware of. And I also want to reinforce that it's never been more important to get these issues out, as we've got this greater trend in admissibility in evidence law, towards admissibility, that is, and it's really very important that cross-examination be done effectively. We would have seen in the Crown and Keller one last week in the readings that I think the quote is, "Sources of untrustworthiness and inaccuracy are best brought to light under the test of cross-examination," and it's really fundamental to our adversarial system. And that's not really a new concept. I had a chance to read certain portions of a book called The Art of Cross-Examination, written in 1902 by an American, and it's a similar thing, is that better than the oath, better than any sort of trial safeguard we have, is the principle that cross-examination is the best method for testing reliability and credibility of evidence in the trial process. So those are important things I want to reinforce. It's also important to note that there's very rarely, or maybe not very rarely, but less than you may think, genuine perjury going on. It's more often than not genuine misperceptions of what occurred, and things of that nature. People rarely lie to the court, or maybe not rarely again, but it's more often misperceptions and things of that nature. And cross-examination is one of the best ways to draw these inferences. We saw in that My Cousin Vinny cross-examination a few weeks ago, that gentleman probably genuinely believed that those kids were the cause of that crime and they were there at that convenience store. However, cross-examination was able to sort of undermine the reliability of his testimony. What time of day, how far away were you, things of that nature. That's one of the tools of cross-examination. So, right. I'm going to start with cross-examination, and as you can imagine, there are very different tools to be used, and I've just sort of tried to get some general principles, some general ideas from various different sources, opinion pieces on what makes either an effective examination and cross-examination. None of these are 100% right. There's no one way to do any of this, but these are some general ideas going forward, and hopefully they're somewhat informative. So, examination in chief. In particular, as I'm sure Drew has pointed out, you're not allowed to ask leading questions, and that's very important. You don't want to be, as counsel, seen as the person giving the evidence. You just want to be prodding and pulling and have it seem like they're simply telling their story. And it's a very difficult task to be, at one point, on one hand, being in charge and sort of leading it as you want to present the evidence in the most pleasant lights for your case, for the trier of fact, but you don't want to make it appear as though you're doing it. So you want to be the puppet master, but you don't want the strings to be visible, which I'm sure is a very, very difficult task. And unlike cross-examination, where the lawyer is sort of front out and trying to undermine credibility and reliability, you don't want to be seen. Not literally, obviously, you want to be seen, but essentially it comes down to preparation. Even if it is your witness, you're never sure on the day of the answers you're going to get. They can vary as people, don't always come through and things like that. So preparation is going to be essential. You need to know the case inside out and backwards, and you need to make it seem as though it's just the story, not counsel's version of the stories, and yet be in charge. And I'm sure that's a very fine line to balance, and it's very difficult. But those are the main goals you want in cross-examination, examination in chief. Now, to cross-examination. Presumably there's a perception out there that that's when you get to be, the loud, proud counsel, as I'm sure Riley would have been in our mock trial, sort of undermining the credibility, reliability in films. We saw Joe Pesci do that. I'm sure you've seen Matthew McConaughey do that many a time in many a film. But it's not always that case, although the counsel should be more part of the dialogue, and you're not as limited as you are in examination in chief. You get to really dig down and ask some questions. But two examples of situations where it's particularly difficult would be, for example, where you're cross-examining a witness who would be an adult with disabilities, or also with a child witness, particularly when maybe it's alleged that they've been victimized in some way. There's a general trend towards greater admissibility of both of those, both children and adults with disabilities, and having the reliability of that testimony be tested upon cross-examination. And it's a really fine line to walk, particularly in a jury trial. I'm sure you can imagine that if you're counsel for an accused who's been accused of victimizing either one of a child or an adult with a disability, it's a fine line to walk between really determining if they have the capacity to sort of understand what occurred, if there were any misperceptions and things of that nature. So you want to be able to, bring to light some of the issues with their testimony without seeming like the monstrous bad guys, so to speak. So it's a very difficult line to cross, and it will very much depend on the type of case you have before you, as I've sort of alluded to with those different cases. And if you want more information on those sorts of issues, both the Crown and JZS and the Crown and DAI are good cases to look to for that. And essentially, one of the main ways you can do it, in circumstances where someone is genuinely hiding something, it's not going to be simply counsel asks a question and then you get the answer, and then that's the credibility undermined. It's best to sort of walk people through an indirect route, as you would have seen Mr. Dearden do with Mr. Koski. He didn't ask those particularly troubling questions at the beginning. You sort of get them to concede to something small, and then slowly walk in the direction you want, and you get to sort of take control as you would, and maybe even more so with cross-examination than an examination in chief. Preparation will be everything. You have to be able to think on your feet and adjust your line of questioning based on the answers you get, and they may not be the answers you want, or they may not be the answers that you believe to be true, but that's really the name of the game, is being able to think on your feet. So those are really my main points. I can't believe I'm already at 8 minutes. But both with examination in chief and cross-examination, preparation is essential. There is no one way to do these things, but with examination in chief, you want to be the puppet master without seeming like you're, leading them in any one way or the other. And cross-examination is really when you get to sort of flex your legal muscles, but it's not quite as simple as you may believe. It's not always as black and white as they're an untruthful witness. There may be just genuine misperceptions, and it will depend very much on who you are questioning. Anyway, that's my time. I'm really sorry I couldn't be there, and I hope that was somewhat informative. All the best, everybody.